If your company has been wound up following a winding up petition, it may be possible to apply to a court to rescind the winding up order. All that means is to effectively cancel the winding up order and allow the company to continue trading. However, it does depend on the reasons why the company was wound up and the evidence in support of the application. It is very important to note that there are strict deadlines to make an application for rescission. These are detailed clearly under paragraph 9.10 of the Practice Direction on Insolvency Proceedings and Rule 1259 of the Insolvency England and Wales 2016. Essentially, the application has to be brought within 5 business days after the date the company was wound up. So essentially, you've got 7 days or a week to make that application. The court has the power to grant an extension of time if you are outside the 5 business day deadline. However, it's a jurisdiction that is very, very cautiously exercised. So you must include an application for an extension with your rescission application and provide evidence for the reasons why an extension should be granted. It's not a given that the court will extend time, so there has to be very clear reasons and cogent evidence supporting an extension of time. So who can make an application to rescind a winding up order? The application can only be made by either a creditor of the company, a contributory, such as a shareholder or anyone else who would be liable to contribute to the company's assets in the event of insolvency, or by the company jointly with a creditor or contributory. A director alone who is not a shareholder of the company does not have jurisdiction to present an application for rescission. If the director is also a creditor of the company, for example, if he's loaned the company money, then he would have standing to make that application. But it's very important to be clear that the applicant has locus to bring that application in the first place. In terms of the evidence required in support of your application, it is crucial that you provide evidence that the company is at least cash flow solvent or is otherwise not hopelessly insolvent. Now, this will include an up-to-date statement of the company's assets and liabilities. So if the company's accounts are overdue, you'll need to make sure updated accounts are filed, or at least an updated balance sheet. Sometimes, depending on the circumstances, a cash flow forecast might be necessary from the company's accountants to demonstrate to the court that the company is able to continue trading. In addition, the court needs to understand the reasons why the company was wound up. And this can include a variety of reasons, including whether the company was aware of the winding up petition, was it served with a statutory demand first, and can the company continue to trade if the winding up order is rescinded. As to serving your application, as soon as your application is lodged with the court and it is sealed, it is imperative to serve a copy on the petitioning creditor, any supporting creditors, or opposing creditors who have given notice to support the winding up petition, and also the incumbent liquidator. Vast majority of the time, the official receiver is the liquidator at the time it's wound up, or otherwise, if it's a private insolvency practitioner, the application will need to be served on those as well. Any appointed liquidator of the company, be it the official receiver or a private liquidator, will normally take a neutral stance on a rescission application, meaning that they will neither oppose or support the application, and they will leave it up to the court to decide the application on its merits. However, in advance of the hearing, the official receiver will lodge a report to the court. Now, that report will outline whether there's any conduct of the company that requires further investigation, or whether the directors have cooperated with their inquiries. Now, this information can assist the court in determining whether rescission is appropriate. In terms of the grounds to rescind a winding up order, the court has a very wide discretion whether to or to not rescind a winding up order. And the burden is always on the applicant to satisfy the court that it is an appropriate case in which to exercise that discretion. And there are no limits to the factors that the court can take into account when assessing whether rescission is appropriate. Generally speaking, the court will need to be satisfied that the petition debt and the liquidation costs can be paid in full, and that the company is at least cash flow solvent. In terms of costs, this will include the petition debt, any accrued interest since the date of the winding up order, the petitioner's costs, which will include the official receiver's deposit, their legal costs, and also the cost of any supporting creditor. Also, the court will need to be satisfied that the application has not been presented in a misleading way and that the court is in possession of all material facts regarding the company's circumstances and its trading operations to consider whether it is appropriate to rescind a winding up order. The application needs to be fair and above board and show evidence that the company does not require any further investigations. The legal principles to rescind a winding up order are helpfully set out in one of the leading cases on rescission applications, the case of Credit Lucky Limited and National Crime Agency 2014, where Marlin J set out the factors that the court will consider with rescission applications. Essentially, these factors are that the power to rescind is discretionary and should only be exercised with caution. The onus is on the applicant to satisfy the court as an appropriate case in which to exercise the discretion, and it will only be an appropriate case where the circumstances are exceptional and the circumstances relied on must involve a material difference from those that were before the court at the time the winding up order was made. Now, in terms of what is a material difference, there's no limit as to what that might be. Now, that can include, for example, where the company itself wasn't aware of the winding up petition. It wasn't either there was an issue in terms of service, or its registered office is that of its accountants and the company wasn't notified, or including where the company failed to attend the first hearing of the petition. Whatever the case may be, these factors have to be properly detailed in the supporting witness statement. Rescission applications are typically heard at the end of the winding up petition list, which presently takes place every Wednesday in the High Court in London. The court only has space to deal with 3 rescission applications at the end of that list, owing to how many companies are in the list at any given week. Now, at the hearing itself, provided the court is satisfied on the evidence that it's an appropriate case to exercise its discretion and rescind the winding up order, it will produce an order compelling the company's house to amend its records and essentially update public records to show that the company is no longer in compulsory liquidation. A copy of that order needs to be served on all relevant parties to that application, which will include the petitioner, supporting creditors, the official receiver, and any private liquidator. It may also be helpful to serve a copy of that order on any other relevant parties, such as any secured creditors or any other lenders who may necessarily be quite alarmed as to what's happening with the company. As to the costs of a rescission application, it is for the applicant to bear the cost of that application. For example, it would be unfair if the application, for example, was unsuccessful and the costs of that were required to be paid out of the company's assets. Now, the official receiver is entitled, in most cases, to retain its deposit towards its general and management fees. Otherwise, if the official receiver has incurred further costs in the liquidation, for example, insurance costs, if there's any valuable assets that need to be protected, it can try to apply for those costs to be paid by the applicant. However, generally speaking, the official receiver is only entitled to retain its deposit towards its costs, and any other costs are payable out of the company's realisable assets in the liquidation. When the winding up order is received, A copy then needs to be served on all relevant parties, including the official receiver or any other private liquidator, the petitioner, and all supporting creditors. Now, the order itself should direct Companies House to update the records to reflect that the company is no longer in liquidation. Now, that process can take a couple of days, depending how busy it is at Companies House, but that is very important because it is public information and the records then need to be updated accordingly. After that, then the company is rescued from compulsory liquidation and is able to continue trading freely. In summary, if you are seeking to rescind a winding up order, it is crucial that you act fast. You have a very limited amount of time to do so, and there are a number of important aspects in terms of evidence that needs to be produced and presented to the court. Here at Edwin Co, we have a specialist restructuring and insolvency team with many years' experience dealing with all aspects of winding up orders, including rescission applications, and we would be very pleased to assist.